right? That voting begins, in the next few weeks. And so that's what people are paying attention to.
Certainly. All right. I know you'll be keeping an eye on it. Evan Perez, thank you. And as we talked about, a good deal of the precedent in this case on both sides involves U.S. v. Nixon and another case, Nixon v. Fitzgerald. We're joined now by former Nixon White House counsel and Watergate whistleblower John Dean. Who better to give us perspective than you, John? So this latest filing from the special counsel once again stresses the gravity of the former president's case and cites U.S. v. Nixon as precedent for a swift decision. As Evan pointed out, saying, quote, here the stakes are at least as high, if not higher. Do you agree with that assessment?
I think they are higher, actually, than U.S. versus Nixon. What we're seeking in the Nixon case were 64 secretly recorded conversations with aides. There were about a half a dozen defendants who were about ready to go to trial, and the prosecutor wanted that set of tapes, 64 tapes, to use in the trial. He had no knowledge that, for example, it would force Nixon to resign when the information was released in those tapes. But he was just preparing for trial, went directly to the Supreme Court, as Evan mentioned, and got a ruling 60 days later. So it is a powerful precedent, and Smith is relying on it.
In your view, is the Supreme Court likely to grant Jack Smith's request here?
I think they will. It would be very telling politically if for some reason they didn't. They theoretically could wait until the Court of Appeals acted, saying they wanted it fully briefed and they wanted to see what the Court of Appeals, where they came out on it. But I think that delay so plays into Trump's hand, and it's so conspicuous to all of us now that Trump's MO is to indeed delay, that it'll be telling politically if they are influenced at all by Trump. And Pam, they have not been to date.
I'm just wondering for context, because at the time in U.S. v. Nixon, it was seen as a big gamble for the prosecutor to skip over the appeals court, go straight to the Supreme Court for a decision. Has that changed in terms of a strategy? Is it more typical now to skip over appeals courts and go straight to the Supreme Court? Just help us understand the context there.
It is more common today than it was. When Leon Jaworski did it in '74 in the Nixon case, it had been way back to during the Truman administration in a case called Youngstown Sheehan Tube versus Sawyer, where they jumped in and did one of these accelerated examinations of the outcome. The president had indeed seized the steel mills, and that's why they wanted to act quickly. But it was a very out-of-pace action by Jaworski. But now, as I said, it's much more common today. There have probably been 5 or 6 cases in the last few years.
So I want to go back to that comparison again, because the issue at the heart of the U.S. v. Nixon was whether a president has privilege in a subpoena fight, not this question of criminal presidential immunity that Jack Smith is currently asking the Supreme Court to consider. You said it's a bigger deal with this case, but is there a meaningful distinction here? Just help us understand that.
Well, the distinction is Nixon was not personally exposed in the criminal proceeding at that point. He was an unindicted co-conspirator, but had no criminal liability. No one knew what he was really hiding, which was the fact that he had indeed, very early in the Watergate cover-up, given instructions to his top chief of staff and other aides that to use the FBI to block the CIA, which was pure cover-up language, not well understood at the time, months and months and months after the cover-up had been undertaken, and the court is looking at this. But Nixon was really hiding one tape in that '64, and indeed when the tape surfaced, it would force him to resign because it put the lie to all of his claims that he had not been involved in the cover-up.
John Dean, as always, thank you for coming on to offer your very important perspective.